Hello, I'm Wajat Ahmed. I'm a visiting faculty at OP Jindal Global University. The module is about international conventions and other standards relating to sexual minorities. Now let's take a look at the intended learning outcomes of the module. The purpose of this module is to acclimatize students to the important international conventions and standards to be compiled by nations that are signatory to an international law instrument. Familiarize students to a few important decisions of regional organizations that have been affirmed the rights of LGBT persons. International human rights principles enshrined in various conventions, treaties, and other instruments can be said to apply to LGBT persons, as well as initially there were no explicit standards prescribed to uphold the rights of LGBT persons. However, LGBT rights have been acknowledged as human rights in various documents at the international level, and the same will be discussed in this chapter. In particular, the Yogyakarta Principles act as a comprehensive document making an exhaustive claim for the rights of LGBT persons. Now look at UDHR, ICCPR, and ICESR, the modern international human rights movement which arose as a result of the events of the Second World War, was silent on the rights related to sexual orientation and gender identity. This oversight happened in spite of the fact that homosexuals were persecuted in large numbers during the Holocaust. In the absence of any substantial treaty on issues relating to sexual orientation and gender identity, the pioneers of LGBT activism relied on alternative exposition of the International Bill of Rights, drawing support from the preamble of Universal Declaration of Human Rights, International Covenant on Civil and Political Rights, also known as ICCPR, and International Covenant on Economic, Social and Cultural Rights, also called as ICESR, which sought to recognize inherent dignity and equal and inalienable rights of all members. They started advocating for their rights. Since UDHR, ICCPR, ICESR all mention without distinction of any kind, it means that this all-encompassing definition leads to the legal documents being applied to everyone, including sexual minorities. Hence, they will have the right to equal protection, right to work, etc. However, since sexual orientation of individuals was never explicitly mentioned in any of these treaties, it was not just interpreted over the years to include such protection. The first mention of sexual orientation was in 1999 in a treaty by CEDAW, which was subsequently followed in many other such documents and treaties. Treaties like CEDAW and ICERD, International Convention on Elimination of All Forms of Racial Discrimination, became milestones as sexual minorities often face double marginalization by being targeted on account of not only their gender but also their race. All these treaties can be interpreted to conclude proscription of bigotry on the basis of sexual orientation. Let's look at the Yogyakarta Principles. A panel of international human rights experts compiled a document titled Yogyakarta Principles, which interpreted existing international human rights instruments and jurisprudence and put down the rights related to sexual minorities in a clear-cut and unambiguous language. In a nutshell, these principles advocate that sexual minorities have the right to be treated as an equal, having the right to universal enjoyment of rights like right to privacy, right to protection from all kinds of exploitation, freedom from cruelty or torture, right to marry and found a family, etc. The principles did not craft new rights or responsibilities, but rather compiled and consolidated already existing rights. Hence, they were just a reminder of the basic tenets present. Each one of these principles is a suggestion of the nature of state's duty to implement the legal obligation. It's important to note that the Yogyakarta Principles have been reproduced verbatim into the text of the judgment in Nalsa versus Union of India, thus ensuring that Yogyakarta Principles in the law of the land in India, by virtue of being part of the pronouncement of the Supreme Court of India. Now let's look at the United Nations. The silence which shrouded rights of the LGBT community was broken by the United Nations resolution of 2011. The resolution expressed grave concern at acts of violence and discrimination in all regions of the world committed against individuals because of their sexual orientation and gender identity. This also led to the institution of a formal UN process to document human rights abuses against gays, including discriminatory laws and acts of violence. A second resolution regarding the same was passed in March 2014. Both these resolutions marked a movement towards finally acknowledging that all individuals are equal and when it comes to matters regarding dignity and rights. In July 2014, United Nations, as an employer, decided to grant equal employee benefits to those in same-sex union in jurisdictions wherein they are legal. Prior to this, these were determined by the laws of nationality, wherein now it encompassed all UN staffers who enter into a legal union. Some landmark judgments passed by the UN Human Rights Committee are as follows. Tunin versus Australia. Tunin objected that Tasmanian laws failed to distinguish between acts in private and public by bringing the former in the domain of the latter, and that resulted in violation of right to privacy under ICCPR. The UN Human Rights Committee upheld that discrimination based on sexual orientation is included in discrimination based on sex. Young versus Australia. In this case, the committee held that it was discriminatory that while unmarried or heterosexual partners were entitled to pension benefits, the same benefits were being denied to same-sex partners. Such denial of pension benefits to same-sex partners desecrated human rights, as this was discrimination on the grounds of sex or sexual orientation. Regional organizations, starting with the European Union. The Treaty of Amsterdam in 1999 was the first treaty to unequivocally mention and protect sexual orientation and gave the European Parliament the legal instrument to take appropriate action to combat discrimination based on sexual orientation. European Court of Human Rights was the first to hear a successful case concerning sexual orientation. In 1981, in Dudgeon versus United Kingdom, the ECHR held that criminalization of homosexual conduct led to violation of privacy mentioned in Article 8 of the European Union Convention on Human Rights. It was held that the right to privacy includes privacy of sexual life. This ruling was reiterated in Norms versus Republic of Ireland and Mardinos versus Cyprus. In Lustin Prayan versus United Kingdom, the ban on homosexuals from serving in military was held to be discriminatory, a fact which was supported by the European Convention on Human Rights. The EHCR ruled in favor of equal benefits for heterosexuals and homosexual partners in Garner versus Australia. Now let's look at what the Organization of American States had to say, or what is known as the OAS. OAS is the Inter-American Commission on Human Rights. In June 2008, OAS brought out a resolution titled Human Rights, Sexual Orientation and Gender Identity. It noted with deep trepidation that acts of violence and human rights violations are perpetrated against individuals based on their sexual orientation and gender identity. Marta Alvarez versus Colombia was the first case wherein the Inter-American Commission dealt with sexual orientation. Marta Alvarez had contended that she was being denied conjugal visits from her same-sex partner, while heterosexuals within the jails were being allowed conjugal visits. The Commission held that the case was admissible and the state should comply, failing which the Inter-American Court could pass a binding decision. The basic tenets of all international treaties and jurisprudential literature on gender equality have one common sentiment and belief: equality to all irrespective of sexual orientation or gender identity. The building of an inclusive community free of discrimination and where every individual is treated with dignity and respect would materialize only when legal changes are supported by change in the way the society perceives such issues. Now let's conclude. India follows dualism, that is, international law does not directly translate to domestic law. This implies that by merely being a party to an international law instrument, it does not become law of the land in India. The Indian legislature has to pass a law that will enact international law in the country. However, it has been well established that when international law does not conflict with Indian laws, then by virtue of Article 51 of the Constitution of India, that urges the state to foster respect for international law and treaty obligations, international law can be made applicable even in the absence of a domestic law. For instance, in the case of Vishaka versus State of Rajasthan, the Convention on the Elimination of All Forms of Discrimination Against Women, 1979, was given effect in India. In this case, the court held that in cases involving violation of human rights, the courts must forever remain alive to the international instruments and conventions and apply the same to a given case when there is no inconsistency between the international norms and the domestic law occupying the field. In the instant case, the High Court appears to have totally ignored the intent and content of international conventions and norms while dealing with the case. Thus, the need of the hour is to urge the Indian state to comply with international law and affirm the rights of LGBT persons in the country. The module ends here. Thank you very much.